I think Menaz very rightfully touched upon a couple of things. It's the time of the signing of the contract when we have to be mindful about the dispute resolution process. And in construction industry, we say these contracts are meant to be kept in the drawer, and they are taken out from the drawer at the time of the dispute when the need of the lawyers arises that we need to do something about it. And then the client or the contractor, they realize what sort of dispute resolution mechanism or the dispute resolution agreement they have entered upon. For example, in Pakistan, there are a couple of segments or a couple of mechanisms that are going on. If we talk about the power sector, most of the power sector, they have got LCIA to be their dispute resolution forum. So most of our power cases, they go to London for dispute resolution. And then we are also a signatory to ICSID. We are very famous in losing ICSID cases. And while this was going on, we entered into the China-Pakistan Economic Corridor Agreement somewhere in 2013. And so we need to understand what sort of contracts has been signed between the two countries. Like the investment started from an initial investment of 46 billion US dollars. So most of these projects, they are either construction infrastructure or from the power sector. And primarily, FIDIC Red Book and FIDIC Silver Book, they have been adopted to be the standard form of contract for all these contracts. So the investment, which was initially $46 billion, is expected to surpass the monumental landmark of 100 billion US dollars. So this is something huge, and we need to first understand what the standard form of contract they are using. FIDIC is the most popular standard form of contract for construction and EPC contracts around the world. You don't have much space to change the general conditions of the contract. But yes, you have the option and the authority to change the dispute resolution clause. Since ICC and FIDIC goes hand in hand, so we see most of the FIDIC contracts, they give mention of ICC to be their dispute resolution forum. I've seen a few of the contracts. They have mentioned SCIA to be the dispute resolution method to the forum. But most of the contracts which are being executed in Pakistan at the moment, whether it be Dasu Dam, we have seen a number of projects that has been quoted since morning, specifically for China-Pakistan Economic Corridor. They have ICC being the dispute resolution forum for if a dispute has been crystallized. So this is where the ICC comes in. I don't know whether both the parties, they were mindful of having ICC to be the dispute resolution forum, whether they understand once the dispute will arise, what exactly is going to happen. Whether are you going to invoke ICC Paris? Is it going to be ICC Abu Dhabi? Or is it going to be ICC Hong Kong? And in whatever circumstance, in whatever the case may be, how things will initiate. So these are the basic things which we need to know at the time of signing of those contracts, which I believe as part of the task force for ICC, we will be taking on this matter, and we will educate and we'll try to provide the awareness to the relevant quarters, especially to the construction sector in Pakistan. Well, I think the efficiency part is like it's cost efficiency and it's time efficiency. When we talk about the cost efficiency, we need to see, like, I don't see it pragmatic that going all the way from Pakistan to LCIA in London is cost efficient in any way. And then maybe at that point of time when we were signing off those power contracts, LCIA was the most appropriate or maybe the only forum that was famous or popularly available in the world. So we had no other option than to opt LCIA at that time. But at this point of time, when we have a number of other places, for example, Abu Dhabi, ICC in Abu Dhabi, SCIA in Singapore, Qatar, QIC, DRC, we have got DIAC in Dubai. We have a number of other places now which are equally efficient in terms of time. Then the question of cost comes in, which is more appropriate for us. So well, I as a practitioner, I used to think, do we have direct flights to those places? Can we have access to those places in terms of if I have to go to Singapore, how much time do I need to have in order to secure the visa? whether they are going to give me the visa in time if I'm a Pakistani national, if I've got a Pakistani passport. So in those terms, I think that is one of the most important driving force that makes us think, if you are thinking pragmatically in terms of the efficiency of cost. So that the very first element that I need to consider, that which is the most cost efficient place. Of course, in terms of time efficiency, as you just mentioned, we have got expedited rules by the ICC, and if you have got certain claim, I think it's $3 million and below, you can opt for the expedited rules. In case you have, you can have the award within 180 days or so, which is fine. But it's not just this expedited rules which are going to impact on all of this decision making. Expedited rules are also getting famous in other arbitration centers, but I think it's the location, it's the seat, which is why I think ICC also comes in, because they're centered in Abu Dhabi, and then we have got direct flights from Lahore, Karachi, and Islamabad almost every single day that goes to Abu Dhabi. So in that regard, we need to learn and we need to understand what will be the cost consequences when we are going to enter into that dispute. Going to England is one option, and then you also need to understand what type of legal system is working around there. You need to hire solicitors and then barristers, and then if you need to go to the court in terms of lex arbitri, what consequences are you going to have? But that's fine. As far as after the 2011 Act, in whatever jurisdiction you are, whether it's Abu Dhabi, it's London, it's anywhere else in the world, it will be considered and treated as a foreign arbitral award. And after the enactment of 2011 Act, as we are hearing since morning, like the pro-enforcement attitude, which is being now adopted and is clearly seen by the various judgments of the High Courts and the Supreme Court of Pakistan, things are getting in a different clarity. So I don't think there is any enforcement issue, whether it's an ICC award or it's an LCIE award or it's an ad hoc award that had been, ad hoc arbitration award that has been issued in any jurisdiction, that will be treated and considered as a foreign arbitral award. And a judge of the High Court is then deputed as the enforcing officer, who is now in line with the pro-enforcement attitude. So enforcement is fine. So these ultimate elements of costs are very important. Cost is something which is an alien concept for the jurisdiction of Pakistan at the moment. We don't have cost consequences. We don't have cost follows the event, loser pays the winner. We are alien to these things. But when we go outside of Pakistan to other foreign jurisdictions, we undergo these heavy costs. I was given the stats that Pakistan alone has paid out almost $300 million in terms of costs only in last 5 years. So these are huge costs these costs need to be considered, and I think this is one of the driving factors that will bring you along in making up the mind of which is the most appropriate place in terms of dispute resolution. Pakistani practitioners, I think it is the time. When I started my practice, there was a new terminology coined in the Pakistani legal market, which was corporate law. It was an alien thing in late 90s or early 2000s. So people who try to pose or to try to tell the market that they are corporate lawyers, they actually made quite a big lot of money as compared to the lawyers who were into litigation. Like we were running around in the civil courts and the district courts, and the corporate lawyers who were connected with the banks and doing those deeds and assignments, and they were making maybe 10 times more money than what the normal ordinary lawyer was doing. This is way back in 2001, 2, 3, 4, maybe 5. But now I think this is the Pakistani market is about to shift its tide. Like, imagine if we are going to have a new arbitration act which is based on model law, which actually emphasize that there should not be a court interventionist approach, rather than the approach should be the supervisory role of the court should be there. And imagine if we have a pre-action protocol mandating parties, just like we have got ADR acts, that you need to do some form of ADR, any appropriate method you think appropriate, then a lot of cases will then automatically start referring to the arbitration if it becomes actually in terms the most effective and efficient way that it poses to be in as the model law says. So I think this is the time when we have to now try to become an arbitration lawyer, or an arbitrator itself. If we need to have arbitrations, like cases coming down for arbitrators, we don't have trained arbitrators. As the chair of the Chartered Institute of Arbitrators, it's been 2 years that we incorporated the branch in 2022, but then our classical dispute appointment service, we were unable to launch that in the market because we never had those trained arbitrators with us who can actually say that they are qualified enough to produce an enforceable award as compared to the TCC Court of England or the international standards. So we started training people. We trained 50 people in just 1 year. We want more people, but it's like a few hundred people as compared to 2.2 million backlog of cases. So for young practitioners, I think this is the time. This is the time to become the old corporate lawyer. The new corporate world will be an arbitration lawyer, I believe.
Yeah.